Thank you so much, everyone, for that incredibly warm welcome and for being here tonight. On behalf of the entire GLAD team, I'm here to offer a bigger picture perspective about some of our work. When I was a law student in 1986, the U.S. Supreme Court upheld the state's power to criminalize same-sex sexual conduct. It mocked, as facetious at best, the idea that gay people's personal relationships had any connection to precedents protecting privacy in family relationships. That case set a national standard of disrespect and essentially cast LGBT people as others to whom the constitutional promises of equality and liberty do not apply. In 2003, that ruling was reversed. And the pace of change only increases. This year, GLAD won not one, but two equal protection challenges to the Federal Defense of Marriage Act, or DOMA. Yes. One here in Boston and the other in the district court in Connecticut. The first one, the Gill case at the Court of Appeals. The second one, the Peterson case. The very likely next stop is the United States Supreme Court, where we expect a very respectful hearing. As many of you know, DOMA requires the federal government to treat married same-sex couples and surviving spouses as unmarried rather than as the married people that they are. We believe the federal government's respect for all marriages, except for those of same-sex couples, violates the Equal Protection Guarantee. And so far, every court has agreed with us. Now, you're going to hear from Herb Burtis tonight, one of the plaintiffs in the Gill case. I have to ask, what does the government gain by telling Herb that his commitment in marriage and his dedication to his spouse, John, over decades is not a marriage for all federal purposes? And before I go any further, I need to express some thanks. First, to the plaintiffs in our DOMA cases, because they, like all of our plaintiffs, are truly paving the way to end sexual orientation discrimination wherever it appears. And I also want to add that we are so grateful to be working on the DOMA litigation with the Boston law firms of Foley Hoag and Sullivan and Worcester, the DC firms of Jenner and Block and Cater Parks, as well as Horton, Shields, and Knox in Hartford. I want to give them all a hand too. I want to fill you in on where things stand with DOMA at the U.S. Supreme Court so you can understand events as they unfold. There are petitions at the United States Supreme Court in 4 different cases, each requesting the court to take that case for briefing, argument, and decision by June 2013. The court could take one case or several. Until last week, GLAD's Gill case from Massachusetts was the only one to have been decided by a court of appeals. That's our unanimous win from last May. Gill also remains an exceedingly strong case for the court's consideration because it has 17 plaintiffs demonstrating how DOMA affects a large number of federal programs like income taxation, Social Security benefits, and federal employee and retiree protections. And I would add, it is the only litigation where a state has also challenged DOMA in a case brought by Attorney General Martha Coakley and her team and the firm of Wilmer Hale. Of the other three cases, one is Glad's Peterson case involving DOMA's application to married couples in 3 states, Connecticut, Vermont, and New Hampshire, and which involves the same federal programs as in Gill, as well as pension issues and family medical leave. Another is the Windsor case out of New York City involving a widow who paid a large estate tax. She won her case in the Second Circuit Court of Appeals last week. The fourth case involves Karen Galinsky, a staff attorney for the Ninth Circuit Court of Appeals, who was denied health insurance for her wife despite being married in California. So now what? No one really knows what case or cases the justices will take until they actually meet in conference and decide, which is likely in November, but possibly later. However, for a case of this magnitude, we have always expected the Supreme Court would prefer to see how DOMA affects a range of people and programs, and the only cases involving multiple plaintiffs and multiple programs are Gill and Peterson, Glad's 2 cases. Now, there's been some speculation that Justice Kagan may recuse herself in Gill and not hear the case because she was Solicitor General of the United States when Gill was filed. Frankly, we have, and no one else has, any reason to know what she will do. She was appointed to the Supreme Court during Gill's earliest stages, when the Solicitor General is rarely involved in defending a case. Also, the government has now changed sides. And finally, as we can see from last term and this term, other high-profile cases, like affirmative action at the University of Texas, a judge's recusal does not keep a case from being considered. So we think Gill is very much in play. Now, no matter what case or cases the court takes, all of the DOMA cases have succeeded by following exactly the same legal path we blazed with our remarkable Massachusetts plaintiffs starting back in 2009. And no matter what case the court takes, Glad is on the team. Glad started this, and Glad will be there taking it over the finish line. Stepping aside from these vexing questions about which case, let's think about the incredible moment we're in. As Justice Ginsburg observed, the history of our Constitution is the story of the extension of rights and protections to those who were once ignored or excluded. That extension of rights takes work. We do that work when we stand up in court or to lawmakers, and we've been doing that for almost 35 years. And here in Massachusetts, we have literally turned the page and broken historical barriers from which there is no going back. The old norms of the otherness of LGBT people are under siege from our collective work of telling the truth. Truth-telling can be profoundly personal. And if you'll indulge me for a moment, long before coming to GLAAD, I told my parents the truth about who I am. They assured me of their love, but as for many parents, particularly then, it was not easy to hear. But love and truth are compelling, and they had to weather the disapproval of others to stand by me. Tonight, I'd like to thank my parents, Al and Jean Bonauto, who are here, along with other family members, for sticking with me. Thanks, Mom and Dad. On a much broader scale, I want to consider just a few examples of truth-telling from the past year. There's the President's journey to support marriage equality, which came from understanding equal protection and because of the LGBT people he knows. And his embrace of this truth and his truth has made room for others to examine their assumptions and approach the discussion anew. Now, how about David Blankenhorn of the Institute for American Values, who was also the only real witness for Proposition 8? He threw in the towel this year, saying, "The time for denigrating or stigmatizing same-sex relationships is over." Exactly. And while we're on Prop 8, I want to say that I am hopeful that the appellate ruling striking down Prop 8 will stand, either because the Supreme Court will not take the case up, or it will take the case up and affirm, and we can all enjoy a landmark victory restoring marriage to California. Some more. Earlier this year, Dr. Robert Spitzer, a lion in the field of psychiatry, finally disavowed a study he had earlier backed, speculating that people can change their sexual orientation if they are highly motivated. No veneer of legitimacy now remains to this damaging claim and puts our full focus where it belongs, on changing discriminatory attitudes and conduct, not on changing gay people. And last but not least, is the emergence in the courts of what is called heightened scrutiny for laws using sexual orientation as a dividing line in how the government treats people. Heightened judicial scrutiny applies when there is a concern that prejudice rather than good policy is at the heart of a law. And that, of course, makes it harder for the government to defend those laws when they're challenged. In February 2011, I was on a call from the United States Justice Department telling us it had come to the conclusion that heightened scrutiny should be applied to DOMA, and as a result, the United States would no longer defend DOMA in court. Now that's what you call a civil rights turning point. And no matter when the Supreme Court decides the issue of the standard of review, it speaks volumes about where we are and where we're going, that a sitting president and now more federal courts are calling out the illegitimacy of using sexual orientation to deny rights and protections. Now, with all these waves of change generated by truth-telling, our adversaries have noticed that we are making progress. And while they would prefer to shut us down with more constitutional amendments banning marriage, among other things, we are still moving forward. So they have developed a plan B, and the idea is actually very simple. Create fear that clergy and individuals who object to marriage will suffer religious persecution at our hands. Use that fear both to defeat legal recognition of same-sex relationships and to create new rules allowing religiously based discrimination in the ordinary business of life. This campaign is in full tilt. In Maine right now, our opponents are running TV ads featuring Vermont innkeepers who were sued under the state non-discrimination law for refusing to allow weddings or celebrations of same-sex couples in any way at their inn. The ad from Maine says, "This is a reason to vote against us." I ask you to think about it. Is this a conflict about marriage, as our opponents would have you believe? No. It's about a business that engages with the public and as such must comply with state non-discrimination laws. That means serving all customers regardless of race and sex and national origin and religion and sexual orientation and so on. And doing so whether that state allows marriage for same-sex couples or not. Second, is it really desirable to allow religious organizations serving the public and the individuals working for them to wield their personal beliefs to deny public services? No. Here in New England, once we win marriage in Maine, knock on wood, we will have 5 marriage states. And we need to keep working to get to marriage in Rhode Island, and also to eliminate, yes, a heinous amendment to the Rhode Island civil union law, one that literally passed in the middle of the night that allows just such discrimination. Now, a taxpayer-funded but religiously affiliated hospital and its employees can deny respect to a same-sex couple joined in civil union and even bar them from each other's side. Now, I want to be clear. Many of us are people of faith, and as our honoree tonight, the Reverend Irene Monroe, demonstrates, people of faith are standing with us passionately on justice issues. But to allow personal beliefs of any sort to justify conduct off limits by the anti-discrimination laws would mean anything goes. It would mean there is no real protection from discrimination for LGBT people. That's just not acceptable to GLAAD, and we're not going to let it happen. Now I want to return to Maine for a moment, where GLAAD has been working for many years to get to marriage, and winning marriage in Maine obviously is profoundly important to the people living there, which includes but is not limited to me and my partner of 25 years, Jennifer Riggins, who's here tonight. But I also want to note that there are strategic implications to Maine that would extend a victory there far beyond our New England borders. For the first time ever, our community is on the offensive in seeking marriage equality at the ballot rather than playing defense when our opponents try to strip it away. And that is why our opponents are calling us bold and dangerous. High compliment. A victory in Maine will prove to those 31 states with marriage amendments that voters can, and in some states will, change their hearts and minds to support marriage, even if they voted against it in the past. Maine is the roadmap about how to find shared values and common ground, and then retake the initiative process to repeal anti-gay equality laws and amendments. And that will create change. A victory in Maine also tells lawmakers, local, state, and national, that the right wing's threats about the people always reversing pro-equality or pro-marriage measures are just plain wrong. They said we could never win marriage in court, but we won right here in Massachusetts. They said we could never win in a legislature, but we won in Maine, New Hampshire, Vermont, New York, and DC. Yeah, it's good. They tout their record of winning 31 states. So our winning at the ballot, starting in Maine, conveys the crucial message that the people are with us, too. So with that, let me just thank you all so much for being here. Thank you for continuing to support GLAAD. when there are so many other demands on you, particularly in an election year like this one. We have so much work left to do to ensure equality under law and equality as a lived experience. We will never stop until we're done. Thank you all.